Contrary to your lordship,
As far as the IA is concerned, it is kept for orders.
I'm DC, Mr. Raju,
Hearing on the 10th. Mr. Raju, let us make
you all know that. Let him not preempt me like this, fellas.
No, I'm not saying that.
Contrary to your lordship's well-established norms, give me just 2 minutes, fellas. We know the fact he's raising. Contrary to your lordship's age-old, well-established norms, that a bail granted is very different from a bail reversed or cancelled. After the bail is granted on 20th, Mr. Raju makes a mention to the High Court on 21st. This is important, Maharaj. On 21st, at the mentioning itself, at the mentioning stage itself, in my presence, the learned judge says the order. He then proceeds to hear us for some time on that day at length, and then Malas reserves orders for tomorrow. Now, my respectful submission to your lordship is 2 or 3 fold. One, the Malas procedure of staying a bail on the first attempt, on the first day, on the first challenge is unprecedented. Second and more important, balance of convenience is totally Malas in my favor. If the judgment is reversed, the man will go back to jail as he did after 3 weeks out under a Supreme Court direction. The Supreme Court had directed him to be out for about 2.5, 3 weeks. He went back immediately. Number two, Malas, he is certainly not a flight risk. He is certainly not somebody who can be controlled. So if the learned High Court were to hear the matter as it is now intending to, this is only a reservation of the order on the interim. Thereafter, it will possibly hear finally in case one of the reacts, it allows Mr. Raju's interim request. Then, Malaj, in that case, the reversal balance of convenience is totally in my favor. I will go back. Suppose the learned judge dismisses Mr. Raju's appeal. How does Mr. Raju compensate me for the loss of time in which I have been kept behind after having got bail? With great respect, this procedure is unknown. In fact, the stay is granted first, the arguments are heard later. The stay was granted at 10:30 or 10:45 on that day, 21st of June, and arguments were heard in the afternoon. And thereafter, it was reserved for tomorrow. I can't hear your lordships. I cannot hear my lords. I cannot hear my lords.
As per the order of 21st June,
yes,
the councils were given opportunity to submit short submissions running in 2 or 3 pages by 24/6/24. That is till today.
Correct. Yes. Yes.
So that means the order is likely to come shortly, maybe in a day or 2 or maximum 2 days.
I entirely appreciate. But Malas, kindly see 2 things here. The order is likely to come, of course, Malas. Normally the order should come very shortly. Can the lordships on mentioning stay an order, then reserve, and then Malas, here the interim, this reservation is on interim, or Malas, the consideration of the interim. Why can't I be free? I am not Malas a flight risk. I can go back to jail the moment I have a judgment in my favor. And the judgment was passed. 1 second, Mr. Chaudhary.
Yes. Yes.
This can up. This can. You are ready also now. So Tilly joins Mayor
Before my friends take over, Malod, your lordships have.
Tomorrow or day after, Malod?
Let me respond to the query that your lordships have already put, Malod, and it is rightly so. First blush, Malod, that is the impression. But Malod, I must dispel some impressions here, Malod. 10:30 Malod, 10:15 or 10:30 in the morning, the mentioning is made. The routine in the High Court was, Malod, that it has to be routed through the Joint Registrar. And only then, Malod, if it disallows, only then it will be mentioned. The Malod Honorable Judge considered it expedient to Malod hear an oral mentioning in this case. But, Malod, while allowing the listing, there is no paper book, there is, Malod, order was not even uploaded. The impugned order had not even been uploaded. There is a direction, Malod, which is oral, that the order will not be executed. Now, my lord, it has set the tone, my lord. That, my lord, which came later in the day when we argued, my lord.
Council is that if we pass an order right now, we'll be prejudging the issue.
My lord, I am only submitting, I am making, my lord,
The High Court.
I am making a twofold submission, my
It's
lord.
not a subordinate court, it's a High Court which is hearing the matter.
My lord, even the court which has passed an order was the court of competent jurisdiction which passed the orders
Without
on two orders.
papers,
Mr.
without
Raju, just for a
paper,
moment.
the judge said
Mr.
that
Raju,
the
please.
doesn't pass the order.
My lord,
Lord, may I come in, my lord, for a second? May I come in, my lord, for a second? Since my learned friend has chosen to make some innuendos, my lord, this is a
I am
peculiar
not making
case
it,
where
it is the ED which is making it, and does not allow me.
only a minute, Mr. Chaudhary, Mr. Chaudhary.
Let me not be gagged, my lord. Just one more.
Yes.
But I just place those submissions there for your lordship's appreciation and perusal, my lord, subject to whatever, my lord, falls. The first factor, my lord, that your lordship passed an order on 10th May 24, it is in challenge to my arrest and remand. There was, my lord, a long drawn argument. All the, my lord, objections which the ED could possibly take were taken. Mr. Mehta and Mr. Raju both appeared and opposed. This court, my lord, while granting me interim bail, albeit for the purpose of, my lord, participation in the electoral process, made extremely pertinent observations in para 15. And I wish, my lord, if your lordship could just have a look at that for a moment, my lord, because that is, my lord, the fulcrum of the entire matter. Please have a look at page 276, my lord. The order starts at page 272. Page 272, my lord, in fact, your lordship may see from 272 itself. The first line, my lord, your lordship will find leave granted. Just notice, Lord, the first line. So this leave is against the, Lord, High Court order which rejected my action for, Lord, challenging the arrest and remand. Just turn to page 276, Lord, para 15. The prosecution has rightly, Lord, got it? The prosecution has rightly pointed out that the appellant Arvind Kejriwal had failed to appear in spite of 9 summons, first of which was issued in October 23. This is a negative factor. There are several other facets which are required to be taken into consideration. The appellant Arvind Kejriwal is the Chief Minister of Delhi and a leader of one of the national parties. No doubt, serious accusations have been made, but he has not been convicted. He does not have any criminal antecedents. He is not a threat to the society. The investigation in the present case has remained pending since August 22. Arvind Kejriwal was arrested, as noted above, on 21st March 24. More importantly, legality and validity of the arrest itself is under challenge before this court, and we are yet to finally pronounce on the same. The fact situation cannot be compared with harvesting of crops or plea to look after business affairs. In this background, once the matter is sub judice and the questions relating to legality of arrest are under consideration, a more holistic and libertarian view is justified in the background of the 18 Lok Sabha elections. My lord, then set me, my lord, exhibit. One second.
Only for that limited purpose.
One minute, sir. Let us decide
No,
this.
Mr. Chaudhary is leading you, Dr. Singhvi. Mr. Chaudhary is leading you.
Right, I was
Let him complete it. Yes.
Because of 2 aspects of 10th May order that have shown to your lordship, lord. First, that leave was granted. Second, lord, that para 15 set the pace for my release despite objections. Now, lord, comes the 17th May order. I am out on bail now. Have a look at 17th May order at page 280, my lord.
This is on your legality of arrest.
Arrest, lord. Now, what happened is to page 281, lord. This is 17th May. Arguments heard, judgment reserved, notwithstanding the fact that we have reserved the judgment and without prejudice to the rights and contention of the appellant Arvind Kejriwal, the appellant may so advise, file an application for grant of bail. If an application for grant of bail is filed, the same will be considered and decided in accordance with law. Parties are 2 facts, if you also could keep in mind. Now, back to the trial court. I asked for Lord bail first, the bail denied by the court, and Lord, the second bail is regular bail. Now, like in 1890th of June, Lord, 2 days extensive
The
bail.
court only had 2 days.
Now, please, Mr. Mehta, let the side in first.
Lord, 2
So we have to say
days.
something on that.
The total time, Lord, I had put in here, approximately, Lord, about 4 hours plus, about total 5.5 hours of hearing, spread over 2 days, more than 3 hours to my learned friend and about an hour and 10-15 minutes to me. The court chooses to deal with Lord, contentions of first Lord, honestly records the contention in its own words. Mine and my learned friend goes into Lord the deduction of or analysis Lord, and in its own words Lord, with utmost respect, it deals with possibly every contention that it Lord considers it to be appropriate and relevant. The last line of that order is Lord that whatever was relevant in the entire submissions, I have Lord disposed of those contentions. This is Lord a discretionary order passed by a court for a person who was released by your lordships already. So Lord, to say that some Lord help it let loose if he is on
First, prejudges the matter at 10:30 because an order is passed without reason. Two, we had cited and we have it in compilation in court 10 judgments of Supreme Court, 10 months, which repeat that your lordships may or may not grant bail, but a bail once granted will not be stayed or reversed easily. It's a totally different jurisdiction. Number three, Mr. Raju specifically concedes in all our presence that he is not arguing administration, flight risk, etc., which are possible grounds or interference with evidence. I'm sorry, it is specifically argued. Now, 1 minute, Mr. Raju, 1 minute.
There can be on two grounds. One is
Mr. Raju,
risk can be considered, but when the order is
Raju, I'm
perverse,
on
it is
VC.
considered. That's not relevant when the order is perverse.
My learned friend says that he's seeking a reversal on the ground of perversity of the order, not on any evidence or ground of interference with evidence. Only on perversity. Number four.
Mr. Singh, just pause.
He alleges.
Pause. Mr. Singh.
Mr. Singh, let us put a question to Mr. Raj. Mr. Raj, we would
Yes.
like to know about the twin conditions of section 45.
Yes.
Have the satisfaction been recorded?
No, not recorded. That's one of our
Recorded.
No, that's jurisdictional point.
More than 4
That ground you have taken.
Yes, and I've taken that ground.
Lord, may I only interject?
Bharat,
May I interject? Mr. Raju.
Order records it.
Mr. Raju, if you don't mind, Lord, allow me to interject only for one line. Am I audible? Am I audible to your lordships? Am I audible?
Yes.
Lord, the honorable court was a vacation judge for 2 days. Lord, there are two conditions. A, the court will have to record the satisfaction that the offence is committed. For the purpose of arriving at that satisfaction, the court will obviously necessarily have to go through the record of the case. Lord, the court starts by saying that this is a high profile case, which it is not. Lord, for the court, Lord, every person is an Aam Aadmi, and nobody is high profile or low profile. Leave it at that. Now the court continuously asks my learned colleague that you cut short the argument. I want to pass the order to
Totally
that,
wrong.
that also will not leave aside.
He will not present.
He argued
No,
to say half hours.
Mr. Dr. Singhvi, please. Now, last point important. The court records in the order that who has the time to go through the record of the case. It is an admitted position from the record that the
In the
court
order of 589, the court says not looked at the papers and passed the order. Kindly have.
therefore that condition is not satisfied.
Paragraph 16 at page 589, the court specifically says they have not looked at the papers. How can an order be passed?
That's very wrong.
That is violation of the conditions of 45. It's a jurisdictional question.
Point is there.
We'll have to go through by block which have been gone through by the High Court. This time,
Kindly turn to the order.
It's possible to go through the
it
papers.
is not.
The court says it's not possible to go through. How can an order be passed?
3 minutes,
I
I will
will
turn
turn
to the order.
That's what the court says.
Order. There can't be a vote.
Sorry. Just turn to the order. I will
Each finding is perverse. Even on dates, the court is wrong.
I can note prima facie demonstrate section 48.
It's a violation of section 45.
Everybody can't argue together. Allow
I will just place your application before the High Court where you challenge that bill.
Yes. Given
First turn to the para of judgment, para small roman 5 at the intermediate judgment. I just take 5 minutes on the paras, they are very clear. The judges.
His application was filed without the order. How could he possibly say it is not compliant? He filed a petition when order was not even uploaded. It is a strange plea they are taking, my lord. With utmost respect, my lord. There are more than 5 paragraphs devoted to 20 conditions. And I would not make it good. So, my lord, therefore, we went to the High Court to hear us extensively, if at all.
my letter may be right because it was filed before the order was uploaded, it is right to that extent. But the fact of the matter is the order, if one looks at the order, it
That's
doesn't.
why he looks at it, Lord.
As far as 45
It is entirely different than what he said.
But kindly read, just allow you to place the order finally.
Limited purpose of asking, permitting to canvass. Now, he has not read 2 important paragraphs of the order of this honorable court.
I can read Lord 4 paragraphs.
623 people.
The judgment has to be read along with the submissions. All are recorded and then whether the discretionary order is passed in a broad base. All contentions are recorded. Please see that. This is never done. 10:30 is said.
Mr. Singhvi, what we propose to do is, we
Yes,
fix a date, say next week, let the court pass an order, let the order of the court come on record. Because unless the order of the court is there on record, we are unable to understand what is the
This is not a problem. Just allow me to at least answer whether I am from BC. I don't know why I appreciate what my lord is saying. That is the catch-22 we find ourselves in. Just consider one thing. Just give me a minute. If the learned judge can stay the order at Mr. Raju's mentioning without reasons, without a copy uploaded, why can't your lordship stay the order before the judgment is given? Kindly see, I know what I am saying. I understand my lord completely. In a normal case, my lord is deferential and waits for the order. But if the learned judge did not wait for the order, the learned judge did not wait for reasons, the learned judge did not wait for a proper appeal to be filed, he first gives his mind and says it, and then hears us. Why is your lordship to be so differential to him? With great respect.
According to you, the High Court committed that mistake, why should we repeat it at another?
No, listen, that's all right, but this is a liberty issue, and kindly judge it, okay, very well, kindly juxtapose it with the balance. I am going to be at the worst losing the matter before the learned High Court judge. Why can't I go back to jail? How is it this case requires me to be in jail?
That is what Mr. Singh or Dr. Singh says, tomorrow the court is going to deliver.
No. He said by tomorrow you
Yes, that is what my saying the order is coming tomorrow, that's what it is.
no date given.
Now, finally, back.
I said it is reserved. I didn't say it's coming tomorrow.
Let us have it here tomorrow.
Yes. And with contention in mind, your lordship does not have to be deferential at all
I
times.
am not expressing any opinion with regard to the merits of what you have contended.
Very well.
But can it be a day more or can it be a day more?
With respect, whether there are problems everywhere, we should have not had a say at all.
No, it's a big case for stay. I'll demonstrate.
If it's You
Well, in
in
fact-
fact, you do it likely to be delivered tomorrow.
Well, in fact, your lordship can keep it tomorrow as last.
Judge said,
No, that-
Tomorrow as last.
It's High Court, let us not pressurize, really, it's not a high profile case, for any one of us.
Only aligned with your lordship does not keep
Normal matter, how would you have gone to High Court?
Normally a stay order, judgments are not, orders are not reserved, they are passed at the hearing
on the spot.
on the spot. So it is usual, but we have.
Very well. Obliged. Obliged. Very deeply obliged.
The order impugned in this special leave petition is an order by which, after hearing the counsel for the parties, orders were reserved on the stay application. And until the pronouncement of the order of the stay application, the operation of the bail granting order was stayed. Full stop. Paragraph. Perusal of the impugned order would reveal that parties were given an opportunity to file short submissions by 24/6/2024. Full stop. The Raju who appears for PSC Raju, ASC, who appears for the director of the person, submits that it is be appropriate that this court adjourns the proceedings to a date so that it may have an opportunity of going to the court. In the facts of the case, we deem it appropriate to direct that this matter be put up day after tomorrow. In the meantime, an order is passed by the High Court, copy of the same shall be brought on record.
One line addition to lordship have noted in the opening lines that we have challenged the impugned order. Not, we have also challenged not an oral order passed at the NSA. Just report that. That's brought also, because that doesn't find mention in the impugned order. There was an oral order passed at the NSA without any paperwork or without any order.
the paper was there.
It is an oral order with
It has to be an
deeply obliged.
Yeah, request for one more day, or it's a day after tomorrow, one more day.
That's very interesting.
a day more, I'm requesting a
You
day.
are asking for today, Malalas. You are asking for today.
See, if the order doesn't come out, something happened.
Day after the tomorrow last matter. It could be.
If not tomorrow, at the worst, day afterwards.
Yeah. Grateful.
Okay.